I'm calling from Los Angeles, and I'm having a little problem under the name That Umbrella Guy. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me. I'm a man.
Whoa, bro. Looking good, man. You working out? You lost weight? Wow. Great suit, by the way. You working out, man? You're looking good. That's a nice suit. What is that? What is that made of? You know, velour? What, a silk robe?
And there, we have fixed it. All right. Well, that was a lot of fun. YouTube, I thought it was a soundboard issue because I was updating that, but no, it didn't connect correctly. It was on the YouTube side, so I had to disconnect and reconnect. Gotta love it. Gotta love it. I thought I boomered the sound for a minute there. I was like, oh crap, you know. Actually, it's funny. I saw the chat was like, "Boomer, your sound, it's muted," and I was like, "Not this time." Not saying I'm above that, because I am definitely not above that. But this time it wasn't that issue, you know. It's fascinating. I've been looking up. By the way, I want to tell everybody, when this case, as we discuss this, so this is a case that you yourself, you can access any document that we go over. I will put a link for it, and I'll give you the case number in just a second there. But you can access all of this stuff on your own. 1 minute here. Hey, little one.
Can you give me a PPG sandwich, please?
We will in a minute. Hey, Sissy will make you one. The jelly's up beside the microwave. Yeah, but I don't know. I don't.
Away.
Yeah, we just go. It's beside the microwave and the top shelf. Close the door for me. Ah, there's the little ones. But, yeah, they're like, give me a PB. She actually said a PP&J. I was like, what? A PP&J? I don't think that's the same thing. But anyway, all right. So, yeah, she was asking for a peanut butter and jelly, but she said a PP&J. So the case number itself that you want to look up, that's it. And the link, as far as DocuSearch, I'm going to put this in the chat too. That way, again, you have the ability to look this up all on your own. You know, you don't have to take anyone else's word on what's been happening. We will, having said that, go over everything. But there have been a few documents that have come up recently, particularly the motion to dismiss and the state actually answering that. Plus, well, let me just put everything up here 1 second. I'll show you everything that's been going on with the case. And then, again, when you search these, everything is public. So, I mean, well, not everything. There have been documents that have actually come up that were not in this, but they were retrieved from the police. But you can see, like, here's all the documents, subpoenas, you know, everything that's been added in. But the thing of, there, listen to them argue about the peanut butter and jelly. one second, I gotta stop there. Hold on 1 second. All right, I think I calmed that down. She was like, I don't want that kind of jelly. I don't like that jelly. I was like, good Lord. Yeah, she's got some lungs on her. Well, she's the smallest, so, you know, you have a 5-year-old and a 10-year-old, and the 5-year-old being vocal is her way of doing it. So she was like, I don't want that jelly. I was like, oh, Lord. Oh. That's so funny, though. At least they're not arguing about SpaghettiOs. No, not today. Actually, they ate earlier. She's like, I want a peanut butter and jelly sandwich for a snack. So anyway, you can see all the documentation now that has been added here. Again. But the thing that's of interest currently is our motion to dismiss. You know, again, you've had a few documents that have come up over this. I actually want to be thorough, noting what's here. So you had Rekieta. You've had their, actually this is the state's answer to, this is the newest, but you've also had a transcript that came up. I'm doing these backwards. I actually got them out of order, but it doesn't really matter. You've had a transcript of what exactly transpired in that. And for today, we have our motion to dismiss. With essentially, what makes this stuff interesting is because you get an idea of how they're going to try to challenge specific items. And the way that they try to challenge specific items, of course, they try to get anything thrown out. You know, they want to go after the validity of search warrant. They want to go after the idea that, well, certain people may or may not, shouldn't listen to them. And again, let's look at this. And I don't know if we'll have time to get this and what the state has to reply. But again, I want to be thorough in covering everything on it. Getting a drink of water, too. Trying to drink more water. You know, because health, apparently, is drinking water and smoking a cigar. Only wood cigar, though, so it's the same one from yesterday. So this, like I said, it gives you a little idea of how things go. And Rekieta actually talked about a lot of the mindset that goes behind it and everything. You can look up his live streams discussing everything relevant here. But for us, I think that we should be able to go through and talk about what's here ourselves and really give it a look over. You know what's crazy too? AJ Stone, I see your gifted membership too. And there was another, but they are not showing up yet. Maybe they'll show up again on the YouTube thing. The only one so far showing up is the Fallen Hero one. Thank you for the gifted membership, by the way. But there was someone else. I don't mean to miss you. I'll check those and see if they update in a few minutes. Like YouTube being weird. Hopefully if something goes wrong with the broadcast, it stops broadcasting for some reason, please note that in the chat. Because when I'm looking at the document, I can see the discussion, but when I put it at this thing, I can't tell sometimes if sound goes out or something. So please note it if something does go wrong in it. But here, okay. The defendant's notice of motion, a motion to void warrant, suppress evidence, and dismiss charges for the lack of probable cause. So please take note again, going on. 21st of August, for then presiding judge, district court, defendant will ask to suppress all evidence collected. And again, we have a transcript of how that went. Derived from unlawful search and seizure, the defendant's home. Hold that the warrant was not supported by probable cause, that the defendant's arrest was unlawful, and to suppress any statements made by defendant subsequent to his arrest, any statements made by April subsequent to her Miranda invocation. I'm interested, by the way, about the Mirandizing of April. That's interesting, you know. We'll see how that goes up, and consequently dismiss counts 1, 2, and 3. So as far as the search warrant not supported by probable cause. Defendant herein asks the court, pursuant to the 4th Amendment of the United States Constitution, Article 1, Section 10 of the Minnesota Constitution, to suppress all evidence resulting from the state's unlawful search and seizure of defendant's home May 23rd, 2024. Now, people have talked about this and whether they think there's issues or not here. A lot of this, I mean, you try to get, you kind of test the waters, as it were, just to see if you can get things thrown out. You know, they're trying. And Rekieta did say something that I do agree with. You have a lot of people that will cover and will talk about things, but they don't show you what it comes from. So for myself, the reason I want to go through the documents themselves is just to say, hey, this is where the argument's being made. This is their argument, whether it seems like a good one or not. Just to show you exactly how they're approaching it. But unreasonable searches and seizures are prohibited by the United States and Minnesota constitutions. Let's see. So you have, the amendment footnote. You'll notice the footnote there. The touchstone of the analysis of the 4th Amendment is always the reasonableness in all circumstances of the particular governmental invasion of a citizen's personal security. They have the quote there again. The footnote, they note what they're quoting. So, we're not going to pull up every one of these that is quoted. I look at footnotes just to see. I will not, on this page, I'm not going to hit footnote because there's not a block of text. I always check to see if there's a block of text we're referring to, but they're just telling you what source this comes from. When a defendant seeks to invalidate a warrant, the two-prong Frank's test requires the defendant to show that, number one, the applicant, quote, deliberately made a statement that was false or reckless disregard of the truth, and 2, the statement was material to probable cause determination. A quote-unquote concerned citizen is generally presumed to be reliable. However, that showing can be rebutted. Concerned citizen. Like I keep saying, as far as concerned citizens go, I do wonder, like I said, we know some of the mandated or mandatory reporter names that came up, people that have talked about this, but we also have a few that are speculated on. So, since the defining characteristic of a concerned citizen is their motivation, some factual background must be provided so the issuing judicial officer may make a determination about the citizen's motivation. The collective knowledge doctrine also applies. Going further, quote, a search warrant is void, and the fruits of the search must be excluded if the application includes intentional or reckless misrepresentations of fact material to the finding of probable cause. In McGrath, the officer characterized his informant as a quote-unquote concerned citizen, but was instead a confidential informant. It appears that the applicant relied not on an informant in the traditional sense, but on the public's exhortations of a self-described quote-unquote concerned citizen, namely Aaron Imholte. Now that name we have talked about again and again. It comes up in a lot of stuff. The beehive, as it were, or the hornet's nest that it was stirred up. It has been insane to watch as this stuff, you know, it's gone from whatever relationship was there to it going bad, to what we saw in public, to what's being noted here, you know, the concerned citizen, Aaron Imholte, talking to the Popo, allegedly. I mean, it's kind of fascinating stuff, isn't it? You also have allegations. Aaron is saying that he was doxxed by I don't know if it was on the kill stream. I don't know exactly where that came up. But he was saying, and again, I'm not saying that he was, or was I haven't even watched this. I just saw the allegations coming up with Ethan Ralph. You've had the stuff with the revenge prawn that has come up. I mean, whew, maybe come up is probably a bad word considering some of the discussion. But in this case, it regrettably appears that the applicant knowingly and willingly misled the court in his application for a warrant. In the warrant, the applicant informed the court that he was, quote, able to review the video that was taken off defendant's YouTube and Rumble social media sites. The video is from, you remember that video, by the way. I think everybody by now is probably seeing at least portions. I actually saw the video in question. I saw the entire live stream, by the way. I saw it before. I didn't catch it. I caught it when it was live, is what it was. I caught it while it was going on, and I figured it might be removed. So what I did is I watched how things played out on 5/21, and then I went back and I watched everything. So I did actually see that when it was there, but a lot of people, I don't know if people have seen the entire live stream. And again, I mention that because it's referred to here in the documents. It was referred to as probable cause. Yeah, anyway. So the video from 5/21, that's the, I'm going to call it the trashed stream, you know. It's of Nicholas in his basement studio talking about a court appeals ruling that he lost. What the applicant failed to disclose to the court is that the video he was watching must have been altered from the original. Given his self-proclaimed extensive amount of experience, the applicant should have stated that the video bears indices of alteration that are readily evident to any layperson. Even more so to a self-described expert who professed to have watched defendant's videos over an extended period. Should the court rule in defendant's favor on this issue, defendant requests this be expressly entered against the applicant. His first integrity, information under, is that a ruling? Okay, yeah, versus U.S. As it has the direct purpose of impeaching the applicant's credibility and adversely impacting the warrant issue. It's a statement of reasons. The applicant offered as an initial basis for the issuance of the search warrant, a report received on May 16th, 2024, alleging, quote unquote, possible child neglect and controlled substance issues. So, they're noting again, that's where it starts out. Now, it was interesting to find out the date range on this, because it was assumed at first that the video caused all of that. If you remember watching this play out from the beginning, many people assumed, again, you had the video, then there were reports, but apparently that wasn't the case. When you look at the documentation, I'm just saying, if you can go back, you can look at the warrant, dates on that and everything. But the applicant failed to disclose to the judicial officer the existence of a letter dated May 20th, 2024. This letter was sent to the Sheriff's Department and to Health and Human Services. I'm skipping the county because I always butcher the county name, and was authored by Children's Services Supervisor Alicia Sweep. Now, Miss Sweep's name has come up multiple times, by the way. It has come up. Initially, when I heard this name, it came up with, well, let's just say a lot of not flattering statements. I'm gonna go with that. You can expand on that. You can actually look at the. I covered. I think it was the first YouTube reappearance that Rekieta did, where he. I don't remember, again, some of this blurs together, but the way I think that, oh yeah, I remember now. So that was when documentation came up talking about what was going on with CPS. You had documentation that did not come off of the search that I showed you. Instead, somebody went to they went and pulled up records, maybe at the police station. I think, I don't know exactly what facility they're going to, but they're going in, they're pulling those up, and it really looks like they're photographing them off a screen, because the quality it's not good at all. It's very rough. But that day, the live stream that was intended, it, I think, changed direction, and it became about what was going on. You had clarification, I'm going to say, on certain things, but you also had names come up, and that was the first time, and that name has just, it's been seared in my mind because of that live stream. That's the reason that I can still remember that. But in this letter, Ms. Sweep informed the Sheriff's Department 2 days prior to the applicant's search warrant application that the May 16th, 2024 report does not fit the definition of child abuse or neglect as defined in the Minnesota Statute Chapter 260E, reporting of maltreatment. Now, that's interesting. I want to see all that. So the applicant's failure to inform the judicial officer of this letter prevented the judicial officer from approaching a warrant based on the May 16th report with facts necessary to authorize the intrusion upon defendant's home and repose. Applicant's failure to inform the judicial officer prior to termination is material, as the initial predicate for seeking a warrant had already been deemed insufficient by the very county agency charged with protecting children. Now, I'm wondering, is that why we did not... See, there was always the question of whether, or not whether, but why CPS didn't initially knock on the door. Because, again, it was questions about child safety that were brought up. I mean, you saw them. You saw them mentioned in probable cause warrant. And yet you had I'm going to say a significant delay. Maybe that's why, because they were saying, well, you know, as far as this particular issue is concerned, that doesn't meet the requirements. How did they put it? That does not fit the definition of. So applicant asserted that defendant and Imholte, quote, may have recently had a falling out. This is an intentional misrepresentation by the applicant. In the 5/22/2024 video blog by Imholte, referenced by the applicant, Imholte makes it clear that the relationship with defendant had downgraded far beyond a mere quote-unquote falling out. Imholte, starting at, they give a timestamp here, states, quote, peace, brother, is not what Nick told me when I said I would not be hanging out with them anymore. The text I got was something about what a flabby, misshapen, doughy piece of shit I am. That does sound like a Rekieta quote, by the way. That very much does sound like that. When I read that, you know, there's certain things, like when letters are quoted in something and somebody says, did that actually originate from them? I don't feel like I'm going out on a limb and saying, yeah, that sounds like something that might have been written there. And the world would be better off if I to myself. Then Imholte, starting at another timestamp, later on, again, a couple of minutes, then states that he communicated to Nick, quote, okay, addict, and then Imholte blocked defendant's number. Applicant admitted from his affidavit that Imholte had made several threats, ranging from a thinly veiled to full-throated against defendant. Imholte stated, starting at, again, timestamp here that goes back before, Nick, sweetie baby, first of all, get help. Second of all, you better hope, and I said that this last night, you better pray to God I don't say what I want. If I said what I want, mofo, it's Mount Vesuvius. Let's make a quick rule for Nicky boy here. You keep my name out of your effing mouth in ways like that, and I can promise I'll be as good a boy as I can be. That actually does sound like a Aaron Imholte quote too, actually. You know. The Nicky boy, that actually does sound like one of his. You know, with someone that you've heard quite a few times saying things, you know, you'd be like, yeah, that really does sound like a direct quote there. Imholte then proceeded, starting at, again, about a minute later, to compare himself to Lefty Rosenthal, popularly analogized as Ace Rothstein from the film Casino, stating, you want to keep a guy like that happy, right? Because he could blow your shit. Because he could blow up your shit, right? Imholte made this comparison and similar threats at multiple points throughout the video. So it tells you, you know, again, here's the actual video. A more perfect Reich, by the way. Interesting. Let's see, where was I? Okay, right here. Applicant misrepresented both the extent of the quote-unquote falling out between Imholte and defendant, and also his overt personal animus, bringing his statements well outside of the realm those of a quote-unquote concerned citizen. Applicant stated on 5/22/2024, Imholte did a video blog where he talked about Nicholas and insinuated controlled substance use, and also referenced a video blog. The Nicholas put online 5/21/2024 that has since been taken off the internet. Aaron Imholte clearly states, starting at Again, timestamp here in the video blog. So this woman who clips a bunch of shit from my show, from Nick's show, DM'd me this. I'm going to say they're probably, I'm going to guess that's a statement about illicit clips. It was Nick's telling a disjointed, drunken story on a stream. Here's the clip that got me riled up. The accompanying clip that Imholte plays in the video blog is, they give the length long. Applicant states that the defendant's, quote, video blog is 4 hours and 4 minutes long. Applicant therefore knew that the video presented by Imholte in his video blog is an altered rendition of Rekieta's video and cannot be authenticated. Applicant failed to inform the judicial officer of the unknown provenance and unreliable nature of the edited video clip. So essentially they're saying, yeah, you know, that was a very long live stream. The clip taken from that was referred, that was not referring back to the original, therefore altered. Or therefore you can't prove. It's an unknown provenance. Applicant misrepresented that he had been, quote unquote, able to review the video that was taken off Nicholas' YouTube and Rumble social media sites. Applicant stated that the video was, quote, taken off of the social media sites. This was a misrepresentation, as those videos were placed in private status on each platform 5/21/2024. If a user attempts to access the video link on each of the social media platforms, they're informed that the video is private. That's true. The user must have special permission to access the video. That is actually true. The way that that works, by the way, for some reason you don't know, you can unlist something. Like if I take something, I can have it public. Like this is right now. You know, it's just sitting out there for the world to see. You can make it unlisted, but you can still click the link. You can actually check it out that way. Or you can private that. And in priving it, I don't even know if you, I can't remember. I don't think you can link to it at all unless, you know, I don't know if any kind of permission can actually be given to see that. So in order for the applicant to be able to review the original video on YouTube, he would have had to have a search warrant on Alphabet Inc., the parent company of YouTube. That warrant was not produced in discovery and is a potential Brady violation. Okay, so this is again linking decision, and we'll have supplementals that are noted. So again, no block text that I'm skipping. More likely, applicant's assertion that he was quote unquote able to review the video did not necessitate serving a warrant on Alphabet Inc. because applicant reviewed an edited version titled Nick Rekieta's Drunk Stream after losing his appeal. In discovery, the state produced a PowerPoint presentation with what purports to be a clip of defendant's May 21st, 2022 live stream video, as well as an image purporting to be a screenshot of the same. Not only is this video titled different, it came from a different YouTube channel, that would be the channel Backwards Internet, and was uploaded as a different date, time from defendant's original. It also contains a watermark not present in the original video. The watermark is open and notorious in the lower right-hand corner of the video and appears to mimic the branding of the edited video's host channel. Applicant did not review defendant's original video. This was a misrepresentation of material fact to the judicial officer. Again, when we're reading this, by the way, the state does answer this stuff. So, you know, like I said, we're seeing what he has to say about this, their approach, and we'll see the answer. And down the road, we'll see what happens. For the reasons pursuant to Franks, the court must find that the search warrant, devoid of any reliability, lacked the necessary probable cause and is therefore void. Firearms seizure was unlawful. Even if the court finds the unsupported and contradictory statements by the applicant sufficient to perform probable cause, the seizure of the alleged firearms was independently unlawful. The alleged firearms. I'm going on a limb and say the firearms, they are alleged firearms. They were, in fact, macaroni projects. I know why they put it there, by the way. It always makes me laugh. Well, the alleged firearms, dun, 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 they were really paper clips. So it notes, quote, the right of the people to be secure in their homes, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue, but upon probable cause supported by oath and affirmation, and particularly describing the place to be searched and the people or things to be seized. The Minnesota Constitution contains nearly identical language aimed at fettering the intrusion of government actors upon the rights of the people. Each constitution requires that a search warrant, quote, particularly describe the things to be seized. The requirement for particularity serves to, quote, prohibit law enforcement from engaging in general or exploratory searches, quote, by limiting the authorization to search to the specific areas and things for which there is probable cause to search. The requirement ensures that the search will be carefully tailored to its justification and will not take on the character of wide-ranging exploratory searches the framers intended to prohibit. Let's see, does this quote go all the way down? All right, I was seeing how long this quote was. I was making sure, when it broke off, I didn't just end. The particularity requirement prevents officers from conducting a, quote, general exploratory rummaging of a person's belongings. The requirement is one of, quote, particular accuracy rather than hyper-technical one. In assessing whether a warrant is sufficiently particular, we consider the purpose for which the warrant was issued, the nature of the items to which it was directed, and total circumstances surrounding the case. Even in circumstances unlike the instant case, where the affidavit in support of the search warrant is constitutionally sufficient, there are occasions when law enforcement exceeds the scope of the search warrant, as a district court judge found in Steele County case 2019. The Court of Appeals, while overruling the district court, provided an analytical framework for the instant case. Again, these are all, we won't look through citations because, again, this is noting what case this came from. Many of these footnotes, by the way, as we go forward, you'll notice they all refer to state verses, and you'll notice where that comes from. Again, you can pull up all these if you want to look up every freaking footnote in that. Go to town. I'm not doing that myself. Even in circumstances unlike the instant case, right here in Sexter, my bad. I was like, wait a minute, I think I read that part. Law enforcement executed a search warrant that authorized the seizure of, inter alia, a, quote, white dish towel-like cloth used by suspect following the essay, which is believed to be located in the red shed. Law enforcement ultimately seized, quote, 4 towel-like items, 2 that are entirely white, 1 that is white with a floral design, and 1 that is both light blue and white in a striped pattern. Following his contested omnibus hearing, Sexter's motion to suppress the seizure of the blue and white striped towel, claiming law enforcement has exceeded the scope of the warrant, was granted by the district court. The court, here's the note, the district court reasoned if the blue and white striped towels were purely or mostly white, like the 3 other towels, the search warrant would have easily covered the blue and white striped towel. If the victim had described the towel as light colored or simply as a towel, the towel would have been omitted. It is not, however, plain white as described in the warrant application. The district court rejected the state's argument concerning the plain view doctrine. Man, that's crazy, by the way. Like, not with his statement, just that case, what's being said there. So, a alleged victim, when they're talking about something happening and they describe an item, the description there, if they would have said a towel in a description was quote unquote lightly colored, then that would have given probable cause to pick up multiple towels. But since they described it in a specific way, it omitted picking up an item. That's amazing, isn't it? It goes with that less is more approach. You know, we hear about all the time. So the state, pursuant to, can they give a statute here, sought a declaratory appeal, which the Court of Appeals granted. The Court of Appeals held that because this involved a determination by the district court that law enforcement exceeded the scope of the search warrant, it was not a challenge to the validity of the warrant itself, but to the way that it was conducted. An argument that a seizure exceeded the scope of a search warrant is a challenge to the actions of officers who executed the warrant. The two issues are somewhat interrelated in the sense that the degree of particularity of a search warrant may make it more or less likely that officers will seize items that are not described or arguably not described in the warrant, and the defendant conceivably can make either argument when moving to suppress evidence. Ultimately, the Court of Appeals vacated the order of the district court, finding that even if the blue and white striped towel was not described in the search warrant, there is, at the very least, a strong relationship between the blue and white striped towel and the white dish towel-like cloth that was described in the warrant. Okay, so they didn't, okay. I was like, man, I would hate, like, you go in, you know, again, there's an essay, and the person says something like, yeah, you know, they clean themselves off with a white towel. I'm like, you didn't say lightly colored. You said white. So apparently that was actually vacated. I was like, man, otherwise, whoo, man. So no such strong relationship exists between the items described with particularity on the May 22nd, 2024 warrant and the seizures of firearms alleged to have been found at the defendant's home. That warrant authorized the defendant's home to be searched for the following controlled substances, including methamphetamine, cocaine, any other controlled substances prohibited by law, and paraphernalia commonly associated with the sale or use of controlled substances, and items that would show controlled substance use that would not qualify as legal drug paraphernalia. May 22nd, 2024 warrant authorized state actors to, quote, seize and keep said property and things in custody until dealt with according to law, including authorization to have seized property and things to be analyzed by a forensic laboratory. The controlling law in Minnesota regarding the seizure of items not described in a warrant is, Michelson? 73, Minnesota Supreme Court case holding, relevant part that, quote, the rule in Minnesota is that police executing a search warrant may seize items not described in the search warrant provided there is a strong relationship between the seized and described items. Phrased differently, it is proper if the seized items clearly and directly relate to the behavior which prompt the issuance of the search warrant. None of the described behavior prompting the issuance of the search warrant is in any way related to the possession of firearms. The behavior described by persons unknown and a person known to have great animus toward the defendant. So that's interesting. By persons unknown. So, do know one person that has described things, again, that they're noting for the probable cause, obviously. We know that was Aaron. Persons unknown. Perceived nonconformity to the mores of a religious community the observations of alleged inebriation viewed through the prism of a third party, all of which were attributed by the applicant to the consumption of unlawful narcotics. I figured that would actually be part of the argument too. I mean, essentially, how do you know that he wasn't just drunk off his ass? You know, I figured that would be, again, when I state this is just, you knew they were going to argue and try to suppress items. You know, like the substance on your nose. How would you know that that was actually the substance that you were saying? How do you know we weren't eating powdered donuts or it wasn't a skit? And, you know, these are questions, again, I was curious about because I didn't know how probable cause worked with internet videos. I talked to quite a few lawyers during that. It's fascinating, too, how when you talk to 10 different lawyers, you may, at minimum, you may get like 3 or 4 different opinions on something. But we talked about all of that. Because, it's fascinating to me that probable cause, how much of it can be built simply off of something that someone's live streaming, you know, and that impacts a lot more people than I think, folks are aware of. So the applicant, despite claiming the defendant, quote, is known to applicant and to the sheriff's office because of swatting phone calls, failed to inform the judicial officer of the likely presence of firearms, which the state's disclosures have revealed were known to state actors. This omission renders any suggestion of a nexus between the purpose for which this search warrant was issued, the alleged presence of narcotics, and the seizure of firearms devoid of rational basis. 2 years after Michelson, the Minnesota Supreme Court lightly tapped the brakes on the rule established therein. Lightly tapped those brakes. In a case involving the seizure of papers bearing the defendant's names found in a bureau drawer with drugs, which were identified on a search warrant, the court held a lesser standard applied. Although one might argue that there is a strong relationship between the papers and the narcotics, we prefer to rely upon the requirement of Warden versus Hayden that there be a nexus automatically provided in the case of fruits, instrumentality, or contraband between the item seized and criminal behavior. Under this test, it is clear that the officers had probable cause to believe that the papers were seizable because they were immediately usually recognized as evidence which would be connecting the defendant to the drugs found in the bureau drawer. Let's see. Okay, so again, all of these footnotes, by the way, they're coming from one specific item. So the court reasoned, quote, since the papers came in plain view of the officer, while they acted within the scope of lawful search pursuant to a warrant, and because they had probable cause to believe that the papers were searchable, a seizure of the papers was proper. Even if the court determines that the May 22nd, 2024 warrant is lawful, the seizure of firearms alleged to have been found at the defendant's home was unlawful, and any evidence thereof must be stricken. What distinguishes Severson from the instant case is that, again, if I mispronounce it, Severson, officers seized the papers for use in providing defendants constructive possession of the pills. Here the officer had no need to seize the alleged firearms to prove defendants' alleged possession of narcotics. The circumstances of the instant case lack even the lesser standard of quote-unquote nexus as articulated in Severson. The plain view doctrine cannot rescue the state's actors from their negligence or malfeasance. I always like that word, malfeasance, by the way. The United States Supreme Court described this doctrine, its benefits, dangers, and pitfalls. In a seminal 1971 decision, well, it's a lot of decision, by the way. It is well established that under certain circumstances, the police may seize evidence in plain view without a warrant. But it is important to keep in mind that, in the vast majority of cases, any evidence seized by the police will be in plain view, at least at the moment of seizure. The problem with the quote-unquote plain view doctrine has been to identify the circumstances in which plain view has legal significance rather than being simply the normal middle of any search, legal or illegal. Give me a second, I gotta have a drink. My mouth is dry today, man. Drinking a lot of water. Water for the win, baby. An example, the applicability of the plain view doctrine is the situation in which the police have a warrant to search a given area for specified objects and in course of search come across some other article of incriminating character, where the initial intrusion that brings the police within plain view of such an article is supported not by the warrant, but by one of recognizable exceptions to the warrant requirement. The seizure is also legitimate. Thus, the police may inadvertently come across evidence while in hot pursuit of a fleeing suspect, and an object that comes into view during a search incident to arrest that is appropriately limited in the scope under existing law may be seized without a warrant. Finally, the plain view doctrine has been applied where a police officer is not searching for evidence against the accused, but nonetheless inadvertently comes across the incriminating object. What the plain view case have in common, or plain view cases, have in common, is that the police officer in each of them had the prior justification for an intrusion in the course of which he came inadvertently across a piece of evidence incriminating the accused. The doctrine serves to supplement prior justification, whether it be a warrant for another object, hot pursuit, search incident, lawful arrest, etc., and permits warrantless seizure. Of course, the extension of the original justification is legitimate only where they're immediately apparent to the police and they have evidence before them. Plain view, it says plan view. One of the things I've learned reading so many documents, typos. They do a lot better with typos than I would. I'd have typos everywhere and something like that. Doctrine may be used to extend a general exploratory search from one object to another until something incriminating at last emerges. The rationale for plain view exemption is evident if we keep in mind two distinct constitutional protections served by the warrant requirement. First, the magistrate's scrutiny is extended to eliminate altogether searches not based on probable cause. The premise here is that any intrusion in the way of search and seizure is an evil, so that no intrusion at all is justified without a careful prior determination of necessity. Second, distinct objective is that searches deemed necessary should be limited as possible. Here, the specific evil is that the general warrant borne by the colonists and the problem is not the intrusion per se, but of a general exploratory rummaging in a person's belongings. The warrant accomplishes the second objective by requiring a quote-unquote particular description of the things being seized. The plain view doctrine is not in conflict with the first objective because plain view does not occur until a search is in progress. In each case, the initial intrusion is justified by a warrant or by exemption, such as hot pursuit, or search incident to lawful arrest, or by extraneous valid reasons for an officer's presence. And given the initial intrusion, the seizure of an object in plain view is consistent with the second objective, since it does not convert the search into a general or exploratory one. As against the minor peril Fourth Amendment protections, there is a major gain in effective law enforcement where, once an otherwise lawful search is in progress, the police inadvertently come upon a piece of evidence, it would be a needless inconvenience and sometimes dangerous to the evidence or to the police themselves to require them to ignore it until they obtained a warrant particularly describing it. The limits on the doctrine are implicit in the statement of its rationale. The first of these is that plain view alone is never enough to justify warrantless seizure of evidence. This is simply a door of the familiar principle described above, that no amount of probable cause can justify a warrantless search or seizure absent extended circumstances, incontrovertible testimony of the senses that an incriminating object is on premises belonging to a criminal subject may establish the fullest possible measure of probable cause. But even where the object is contraband, the court has repeatedly stated that enforce the basic rule that police may not enter and make a warrantless seizure. That was long. That was a lot. I always wonder when I read something, judges, I look at all that. Like the one thing I always wonder when I look at something, it goes with the, we were talking about the Gina Carano filing and the way that it looked. It had things in there that you would think, wow, that's a little prosaic, right? That seems a little silly in its own way, but it was also very eye-catching. You don't zone out in the middle of it and think, oh, blah, 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 blah. And I always wonder, with a judge, I know judges and what they're supposed to do, but if you make things pop, if you're like, ooh, look at that. Again, with Gina Carano, that filing, when I read it, I was like, man, this is kind of entertaining. It's an entertaining filing. And it would definitely catch a judge's eye. And it would do more than catch their eye, it would catch their attention. I always wonder, if you put too much like that in, did they get bored and like, all right. So the rule in Coolidge, as modified by Horton, as applied to the circumstances in the instant case, demonstrate that even if law enforcement intentionally or inadvertently discovered the alleged firearms at the defendant's home, their seizure was unlawful. Even the rapidity of which the applicant was able to secure the initial search warrant 4 minutes from his signature to approval by Judge Fisher, and the arrest of both adult occupants of the defendant's home as well. Isn't Judge Fisher, by the way, the judge that April Imholte was in front of? She, we'll go over that one day too. Well, wasn't that the judge that was there for hers, if I'm well remembering? Because I figure they're like many places that are small. You're going to have not quite a few judges. You've got a small selection. So I believe that judge. I believe that they say, well, we'll go over, like I said, I've marked all this. I'm catching up everything. I want to be thorough. You may disagree with what I have to say, but I want to make it clear. Like when I look at this shit, I read everything. And you do too. I'm sure like when you go through something like this, you probably want to be informed on the arguments, and you see what works too. I always wonder, will this work? Will any of this work? But anyway. And the removal of defendants' minor children by law enforcement, securing a warrant for the alleged firearms would neither have been an inconvenience nor dangerous. The seizure of alleged firearms was therefore a warrantless seizure from defendant's home without any of the exigent circumstances that must accompany such a seizure. A warrantless search is, per se, unreasonable. A search conducted without a warrant is unreasonable unless it satisfies one of the well-delineated exceptions of a warrant requirement. Since none apply here, the seizure of the defendant's alleged firearms is unconstitutional, and such the fruit of the poisonous tree doctrine requires the underlying firearms charge be dismissed. Now we get to the April Imholte portion. The April Imholte statements and them being inadmissible as to defendant. So April Imholte's statements to Deputy Pomplin are inadmissible as they are testimonial and were made after Miss Imholte was given a Miranda warning and invoked her right to remain silent and her right to have a lawyer present at questioning. Statements are non-testimonial when made in the course of police interrogation under circumstances objectively indicating the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. They are testimonial when the circumstances objectively indicate that there is no ongoing emergency and that the primary purpose of the interrogation is to establish or prove past events potentially relevant to later criminal prosecutions. Statements to police made in response to questioning for the purposes of establishing or proving past events for later criminal prosecution and not to enable police assistance to meet an ongoing emergency are testimonial under Crawford, Davidson, and Warsame. Or Warsame. I'm not sure there. Hey, what's up, Amy? Thanks for the 20 months, by the way. Hey, Tug. To see you. How you doing? I hope you and your family are well. Yeah, we're doing pretty good. Doing pretty good. Appreciate it. On the 23rd of May, 2024, exterior to defendant's home, April Imholte was Mirandized by Deputy Brannis. When asked if she would like to say anything, April Imholte told the deputy, "I would like to remain silent until my lawyer's present." The deputy ceased any attempt to question April Imholte further. Approximately 4 minutes later, deputy headed toward the house to retrieve a pair of shoes for April Imholte. Another deputy, Deputy Bauman, took control of April Imholte. Deputy Brannis headed toward the defendant's home when he about-faced and told Deputy Pomplin and Bauman that "I did Miranda and asked for a lawyer." Now, despite this affirmative notice that April Imholte had invoked her Miranda rights, Deputy Pomplin conducted a custodial interrogation of her to elicit incriminatory statements by telling her side of the story. The defendant has no standing to ask April Imholte's statements be deemed inadmissible. In a pending criminal case, they note criminal case here, it does not ask the court for that purpose. Rather, defendant asks the court to declare April Imholte's statements made to law enforcement following her invocation of her Miranda rights to be inadmissible in defendant's case. This includes any video or audio recordings, as well as any notes made or reports drafted by law enforcement, unless April Imholte testifies at trial and is subject to confrontation. Admitting April Imholte's statements into evidence at trial, absent her testimony, will violate defendant's right to confrontation. So, conclusion. The applicant misled the court in seeking a warrant. Had the applicant been truthful and relayed accurate information, the warrant would not have been issued. For the foregoing reasons, this court should suppress all evidence collected and derived from unlawful search and seizure of the defendant's home, hold that the warrant was not supportable by probable cause, that the defendant's arrest was unlawful, and to suppress any statements made by defendant subsequent to his arrest, any statements made by April Imholte subsequent to her Miranda invocation, and consequently dismiss counts 1, 2, and 3. Let's see, anything else? Okay, so that is one of our documents here. Okay, and again, give me 1 second. One moment here. I'm making sure of something just for a minute. And I'm pulling up the site itself times out. So what I'm doing is I'm going back. There's so much crazy stuff, by the way. Give me 1 minute. I had to pull, what I'm doing is pulling the case number. I can never remember the entire case number just right off my head. I know. So I'm inputting, I'm going to show you where we are with items. Now, again, the motion to dismiss. Give me 1 second here. Now, the motion to dismiss is, there it is. All right. It's taking me longer than I thought it would. Sorry about that. Note it again. When you look at documentation, you can see exactly what's come up, how this, for subpoenas of service, disclosure, the discovery disclosure. You've seen, by the way, let me see if there's anything that, well, I mean, we could put the discovery disclosure. We'll pull that up real fast. Give me 1 minute. We're not going to cover everything in it or anything. I just want to make sure I'm hitting everything. So the discovery disclosure, that is this item. Again, you've probably seen that with police reports. You just go, it's a checklist essentially. We're being thorough here. The laboratory documentation, etc. So you can see exactly, what their disclosure includes in that. Okay, then we have a transcript of the omnibus hearing. Now the omnibus hearing, that is, see the next item that is actually present. There's transcript listed right here. We'll look at the transcript, see exactly what is noted in that. Oh, man. There's so much here. Okay, so let's check this out. Here's our transcript. You can say again, this is our omnibus hearing. They tell the judge who it's in front of, date, etc., who exactly is there to, assistant county attorneys appear on behalf of the plaintiff. You have Francis White, Nick Rekieta. So the court again, they tell you who exactly is there. They're having an omnibus hearing. Mr. White, did you have some contested issues today? Mr. White is like, yep, Your Honor, we do have some contested issues. Okay. I would, again, they talk about the mic. So we're skipping over that. Your Honor, if I may, please the court. On Sunday, we filed a motion asking for the court to strike all evidence, to suppress all evidence that was collected under the warrant. We based our motion on the two-pronged test, Franks, a case with which I'm sure the court is very familiar. Excuse me, I'm getting drink. Under Franks, there is a requirement that the statement that was made by the reporting officer was false or reckless disregarded of the truth that the statement was material. As I indicated in the motion that we filed, I believe that both of the legs upon which Deputy Pomplin, I believe is his name, based his motion or based his request to the court. I believe both of those are faulty. As I pointed out in the first instance for the warrant, he based that on hearsay, which I concede is admissible, but hearsay from a reporting official a mandatory reporter who reported something to another officer. That other officer, Sergeant Nestor, forwarded that information to the County Health and Human Services, CPS, and CPS, they rejected that. The letter that I submitted is an exhibit in MNDS clearly shows that particular artifice was rejected in the county But even if it hadn't been rejected, that plain language of what it is alleged in Deputy Pomplin's request, his application, doesn't rise to the level of anything to do with drugs. Child endangerment, perhaps. That language in there reflects nothing but child endangerment at best, and it won't even concede that it does that. The second element is that Deputy Pomplin said that he had watched a video on the Steel Toe morning show by a gentleman by the name of Aaron Imholte. Aaron Imholte and the defendant have had I don't want to say a long-standing feud, but it has gone on for months. I would say, yeah, I'm going to say if you have an issue with another person and it airs out like it did, it's probably going to be long-standing if it hits months. They don't like each other, notes. They plain old don't like each other. And from the writing, in the particular application, it seems that the deputy identified Mr. Imholte and his expectation there almost as a concerned citizen. Well, the case law is very adamant that he doesn't qualify as a concerned citizen, because when you're dealing with a concerned citizen analysis, you have to look at what the motivation is. The motivation is important to determine whether someone is a concerned citizen or not. Also, the video, as it's stated in the video that he watched could not have been the defendant's. In fact, the evidence that we received in discovery, their supplemental number 1, shows a clip from presumably the video that he watched, showing that it came from a different platform, and a different platform added elements to that video. So the video in and of itself is not reliable evidence. And the problem with that is that Deputy Pomplin didn't identify that to Judge Fisher. It is my belief that if Judge Fisher had known that the allegations that were made had been evaluated and dismissed, and that the video that Detective Pomplin reviewed was not Mr. Rekieta's video, but was in fact a video that someone else had copied, and then added elements to, she would not have issued that warrant, at least not in the 4 minutes from the moment that from the 4 minutes that he signed it, and then she signed the warrant. 4 minutes elapsed between the application and the warrant. So really, it took 4 minutes to slap that on. They're like, 4 minutes, maybe she would have had a little more pause if she would have known, again, these certain elements. Maybe she would have taken a little more time with that. I assume that all judicial officers take their jobs and responsibilities serious, and in doing so, they rely on officers of the law to be honest and fully forthright and forthcoming in their expressions to the court. I think in this case, these are material omissions that Detective Pomplin did not tell Judge Fisher about, which renders the warrant invalid. One of the other issues that are raised was the fact that the warrant, even if the warrant is valid as to drugs, the police seized firearms, or alleged firearms, I should say, from Mr. Rekieta's residence. Those firearms aren't listed in the warrant. There's no indication that they're looking for firearms. The case law that I cited in my brief, and I won't go over it here, is pretty clear that even when something is in plain view, it has to be related to, substantially related to, or there has to be a nexus between the alleged offense for which the search warrant was granted and the seizure of an item that is not listed on here. There's no nexus here. It's not substantially related. There's no nexus here. The case law on this is pretty clear. The third issue that I raised involves, I like how the person making this transcript, by the way, they include every time, you stop, every time there's an error. It's just kind of fascinating. Some do, some don't. But it involves Miss Imholte's statement to the officer after she had been Mirandized. There's been a lot of confusion about this. So the court says, I'm going to stop you there. That third issue, though, isn't that more so a motion in limine that would be reserved if the matter did get set for trial. I'm not really, I'm not sure if it's proper for me at an omnibus stage to really, discuss admissibility, since it's not a constitutional or legal issue. It seems more motion in limine is what you're suggesting on the last issue. So, Mr. White, that was my initial thought, Your Honor. But the cases cited, Sutter, seems to ended up with the issue being harmless error because, and again, this is something that I'm drawing from my research, that it doesn't state it explicitly because it wasn't raised early enough. So belt and suspenders, Your Honor. Belt and suspenders, Your Honor. That's an interesting one. So yeah, think about belt, think about suspenders. I wanted to make sure that it was raised as early as possible. And the state has conceded, and I'm sure Miss Pierce will tell you that they will not use the body cam footage that I'm asking the court to preclude unless Miss April Imholte testifies. The court says, okay. All right. Thank you, Your Honor. The court, all right. So summing up your first issue then, essentially you're asking for a Frank's evidentiary hearing, and this is important because this is something in the response that's right away what the state is going to address. You mentioned some items you placed in MMDES. Just one moment as I refer to those. That was, well, do you want to detail what your exhibits are? It looks like you have some video recordings, a document image, a letter from Family Services, the application for a search warrant, and another video. Does that sound correct? Now, Mr. White says there are. In there, I'll get rid of the two easiest ones to get rid of. There are two body cam videos because Miss Pierce is conceding that that's not necessary, and those relate solely to the third issue I raised. Those are not particularly relevant. The other video is a copy I personally downloaded of the Steel Toe Morning Show. The Steel Toe Morning Shoe. The Steel Toe Morning Show. I could see myself making that mistake. The Steel Toe Morning Shoe. From May 22nd, 2024. That was their morning show, not the evening show, because apparently there's an evening show as well. I downloaded that. And that video references to times that are in our motion. The application for the search warrant, of course, was to the court already had that, but that was for ease of use. The letter is the letter that I referenced from the County Human Health and Human Services, stating that they investigated the report from May 16th and they found it wanting from any evidence of child abuse or neglect, which is a pretty low standard, Your Honor. The PowerPoint presentation that is titled Rekieta Video, again, PowerPoint dot. That is the PowerPoint presentation that Deputy Pomplin references in his supplemental report 1, which is also included, that he created from someone else's stream, not from Mr. Rekieta's stream, but from someone else's stream. And the Rekieta dot, so the picture there, that is a screenshot taken from that stream. Okay, I've already mentioned the supplemental report, and I think that's everything, Your Honor. What I'm saying is that evidence is not the best evidence. It wasn't the original evidence. And Judge Fisher had an expectation that she would have been informed of that. Detective Pomplin did not inform her of that. In fact, his application indicates that if he watched Mr. Rekieta's stream and seeing, as that is only suggestion that there were drugs in the house, then she had a duty to. She had a need to know that he had a duty to tell her that it had been edited and that she could evaluate that. All right, so the court says, Ms. Pierce, any objection to the court receiving those items? Ms. Pierce says, Your Honor, I would object to the video of the Stilto Morning Show. The affidavit does, for the search warrant, does indicate that they did review a video blog on May 22nd, 2024 from Aaron Imholte, but there are, as Mr. Francis White says, there are multiples per day. I don't know if this is the one that was watched, and I can't talk to the authenticity of the video. So the court says, all right, any further response on that issue? Mr. White says, Your Honor, we're not submitting it for the truth of the matter here. We're submitting it as an indication that there was a different video than what he actually reviewed. But excuse me, that Detective Pomplin watched that show, and that show indicated that there was animosity between the two parties. If you grant us an evidentiary hearing, the Franks evidentiary hearing, I will certainly be asking Detective Pomplin whether or not he watched that video or not. So the court, they're like, all right. Well, I'll take the admissibility of that under advisement. I'll review it and determine whether the court will overrule the state's objection or not. Ms. Pierce, your response there. So, Ms. Pierce, Your Honor, I would ask to be allowed to do a written response. The court's, all right, how much time? Ms. Pierce, if I could have until the 30th. The court's like, that's fine, the 30th. Mr. White says, Your Honor, I would ask to be able to reply to the written response. I need 5 additional days to do that. The court's like, any objection? Typically, this is your motion. I would have you file submissions first and the state thereafter. Mr. White says, my submissions, Your Honor, are already filed. It's like, all right, in the light of that, I'll allow a reply brief. Then by September the 6th, okay. Mr. White's like, thank you, Your Honor. The court, all right. The court will take the matter under advisement as to September 6th and issue an order. Typically, an order will be provided within 30 days of that date. Was there anything else here today? Mr. White says, no, Your Honor, except for Ms. Pierce saying on the record that she did agree that the third element would be that she had agreed that there would be no use of the body cam footage unless Miss April Imholte testifies. The court, Ms. Pierce. Ms. Pierce says, I agree that there would be. I cannot use April's statements unless she testifies because they're hearsay. And I would not show her statement on body camera. I'm not agreeing that I would not use any of the body camera. So again, you see what they're saying there. They're saying I wouldn't use this particular portion of body cam, but I'm not saying I won't use all body cam. Court's like, all right, well, nonetheless, or nevertheless, those items are motions in limine. You've noticed it. It's an issue if the material does go to trial. If there's any further contest of that, we'll certainly discuss that further as well, okay?
Hey, Dad, I made a cake.
You made a cake?
Yeah, not just in a random tin. It's standing up, and I was icing it.
Bang it out. You said you were going to make a cake. Boom!
And I didn't just eat all the batter this time. I actually put it in.
You put it in? You got it
I
all?
put it in the microwave oven because I couldn't, find a dish that I could use.
Yeah. That's cool. That's cool.
I couldn't find a dish I could use, so, I baked the cake.
That's cool, man. I knew you were talking about doing it. Yeah, bump that out. Boom!
Also, guys, sometimes I like to imagine that we're all in a video game. And outside the video game is just edits of us.
Oh no, it's the Matrix, right?
Yeah, and imagine this. You have an edit of some person saying, you are so me. But first name instead of you.
Yeah, right.
Elizabeth is so me. It's just random clips of me talking.
Yeah.
And being all silly.
Well, props to you there. Ugh.
When are you going to be done?
I've got one more document to look over and then I'll be done. Okay?
Yay!
Yeah, she's been working on her baking skills. So she was telling me yesterday. She said, I really want to eat an entire cake batter. And I was like, yeah, it's not good for you. She was like, well, I'm gonna cook a cake. I was like, yeah, that's fine. We'd been messing around with that. And the last try was not the greatest for my, I'm going to say for my edition. So we'd set it up, and apparently I'll get to look at it later, but it sounds like it came out good this time. So anyway, this is pretty much the end of this document here. There's one other document. The court's like, okay, I'll take all that under advisement. And that document they talked about, their submission by the state, well, the state also gave its submission too. So they actually answered the objections. Give me 1 minute.
Want to see the cake I made?
Yeah, give me 1 second, kiddo. Let me park this on this. Yeah, show it to me. Heck yeah, that came out good, man.
Yeah, I tried to make it all circular by cutting the edges.
Careful. Let's look at it.
I put it as vanilla with chocolate icing.
That looks great, man. You did a good job with that.
I tried really hard, and it was so hard to try to bake. And I had to wait 12 minutes.
Hey, we turned everything off like we've talked about, right? Everything's good. Everything's
the
safe.
microwave oven is off.
Yeah, well, of course the microwave, but there's nothing else on, right?
Yeah, but that second microwave we have has a bake setting.
Yeah, it does. Yeah, that's what it's for, really.
So it's a microwave oven.
Yeah, well, sorta. But it's more for baking. Yeah, that's what it's for.
I love eating cake.
Yeah. She was showing off her cake. It looks really good. It came out very well. I'm proud of it.
I think I'm going to add sprinkles.
Yep. You're going to add sprinkles to it? Okay. Do that. There we go. All right. So this is the state's answer. I didn't think we would actually get through this. I haven't tried to give a lot of opinion on anything. I'm trying to showcase the argument, what was requested, and the state and how they answer that. And remember, all through this too, you have other elements that are playing outside of this. Again, remember like Aaron, for example. You have all the stuff that's going on with Aaron right now. If you've missed that, by the way, that's absolute insanity. Again, the revenge prawn warrant that went out for him. So that's playing out. They mentioned this, but you have everything going on with April too, and that attaches to this, but it is not, again, this is Nick. So this is, again, the state memorandum in opposition to defendant's motion to dismiss. So they note there are two issues before the court. First, whether the defendant has made a sufficient showing to warrant a Franks hearing, and second, whether the seizure of firearms was lawful. Based on the arguments herein, the court should deny the defendant's motion in their entirety. By the way, it's a frightening endeavor. I'm going to say, no matter what you think about any case, that it is frightening to go against the state. The state has limitless resources, pretty much, I would not want to go against the state. When we see this in other trials, like here, I don't envy anyone, whether they put themselves in the position or whether they were put in that position. I would not want to go up against. You going up against another defendant, that's not fun, but at least, again, their resources are not limitless. In this instance, though, they are. So, discussion. Number one, the defendant is not entitled to a Franks hearing and cannot go beyond the four corners of the search warrant in a probable cause challenge. So the United States and Minnesota constitutions provide that no warrant shall issue without a showing of probable cause. Again, they note where that comes from. To determine whether the issuing judge had a substantial basis for finding probable cause, we look to the quote-unquote totality of the circumstance. The task of issuing judge is simply to make a practical, common sense decision, whether given all the circumstances set forth in the affidavit before him, including the quote-unquote veracity, the quote-unquote basis of knowledge of persons supplying hearsay information, there is fair probability that contraband or evidence of a crime will be found in a particular place. By reviewing the sufficiency of the search warrant affidavit under the totality of the circumstances test, quote, courts must be careful not to review each component of the affidavit in isolation. A collection of pieces of information that would not be substantial alone can combine to create sufficient probable cause. Furthermore, and again you can see what this hails from, the statements. Furthermore, the resolution of doubtful or marginal cases should be largely determined by the presence to be accorded warrants. Generally, in determining whether a probable cause exists, both the district court and the reviewing court may consider only the information in the application for the search warrant. You note again with review denied. But if a defendant challenges the accuracy of material facts in a facially valid search warrant, the district court is permitted to look beyond the four corners of the warrant application. Whether there was probable cause to support the warrant is decided on the face of the warrant's application and the information contained within the four corners of the document. Second, to go beyond the four corners of the search warrant, the defendant must establish a substantial preliminary showing that, number one, the affidavit contains a false material statement. Number two, the affidavit made, or the affidavit, okay, I was making sure I only messed that up once. Haven't made the false statement intentionally or with reckless disregard for the truth. And number three, the false statement is necessary to support the finding of probable cause. Again, you can see all of the case law where that comes from. The requirement of the substantial preliminary showing is not easily met. To make this preliminary showing, the defendant must make an offer of proof in the form of a sworn affidavit of a witness. ID Franks is limited to cases of perjurious or recklessly false statements or omissions made by a police officer in support of a warrant. The rules do not apply to the negligent misrepresentations or omissions. Here, no affidavit was offered by the defendant, no testimony offered by the defendant or any defense witness. The only challenge to the search warrant comes from the defendant's omnibus motion alleging that misinformation or the lack of information was provided by law enforcement on the search warrant affidavit. The defendant did submit some exhibits in support of their motion. However, their exhibits are incomplete and create a misleading picture of the evidence provided. This is essentially a fishing expedition by the defendant to go beyond the four corners of the warrant. The defendant is attempting to get a Franks hearing without making the requisite showing. Wow, that's a pretty brutal statement, to be honest, in my opinion. The defendant argues that the County Health and Human Services screening out the initial child maltreatment report should have ended the inquiry for law enforcement. The search warrant was not based solely on child maltreatment report. Further, the screening of child maltreatment reports is controlled by an entirely different set of statutes and standards than criminal offenses. Whether there is enough to investigate a child maltreatment report has no bearing on whether or not criminal activity may be occurring. Child maltreatment reports are cross-reported between law enforcement, child protection, That is a state mandate. When Detective Pomplin received the child maltreatment report, he began an investigation into whether or not there was criminal activity related to controlled substances. The purpose of his inquiry is different and not controlled by child protection standards. Both agencies started with the same information provided in the initial report. Applying their unique standards to that information, each agency proceeded differently. It is not relevant that the child maltreatment report was screened out by KCHHS. Even if it was relevant, whether or not the child maltreatment report was screened out by an entirely different agency using a different standard has no bearing on probable cause determination in the search warrant. The report was the basis for the start of law enforcement's investigation. It was not the entire investigation. It was not the sole basis for the application of the search warrant. Even if the court were to strike the information about the child maltreatment report from the warrant's application, there's still probable cause for the search warrant based on Detective Pomplin's subsequent investigation. Let me get a drink real quick. The defendant also argues that Detective Pomplin intentionally misrepresented the relationship between defendant and Aaron Imholte. In the application for the search warrant, Detective Pomplin notes that there was a pre-existing relationship between the defendant and Imholte by referring to prior videos where they appeared together or Imholte appearing from the defendant's home. Detective Pomplin included that, quote, "There may have recently had a falling out between Imholte and the defendant." He also indicated that Aaron Imholte and April Imholte had separated. Detective Pomplin informed the issuing magistrate that Imholte and the defendant were no longer on good terms. The quote-unquote full-throated threats that the defendant references in his memorandum all involve the idea that Imholte knows information about the defendant that defendant does not want to be made public. So they're saying, all of that stuff that he says are threats. Yeah, those, they're not really threats as it were. They're more of threats that I'll say things that you don't want said publicly. This does not indicate something more than a falling out. The statements that the defendant cites as quote-unquote threats are not threats to physically or financially harm the defendant. They are statements about sharing information the defendant does not want shared. Detective Pomplin stated that there may have been a falling out between Imholte and the defendant is not a material misrepresentation of facts. The defendant may disagree with it, but that does not make it a lie. The statement indicates that there is no longer an ongoing relationship. A quote-unquote falling out indicates the ending of a relationship was not on good terms. Even if the statement the defendant cited in his memorandum were included in the probable cause portion of the affidavit, there is still probable cause. The statements cited by the defendant indicate that Imholte and the defendant a prior personal relationship is no longer ongoing. This is the same information provided by Detective Pomplin. Detective Pomplin gave the issue magistrate additional information to judge the veracity of the statement made by Imholte. Detective Pomplin notes that Imholte had personally used controlled substances in the recent past. There are no direct statements by Imholte that the defendant was using controlled substances. Detective Pomplin pointed out that Imholte insinuated use by the defendant, but did not directly state that. Imholte also talked about a video where the defendant appears to be under the influence of a controlled substance. The information provided by Imholte is not the sole basis for the search warrant. Imholte's video, May 22nd, 2024, refers to a video the defendant produced on the day before, we'll say, where the defendant appears to be under the influence of controlled substance. Detective Pomplin did not rely on that statement alone. Detective Pomplin watched the defendant's video for himself. Detective Pomplin has been trained as drug recognition expert, where he received specialized training to identify the signs and symptoms when someone is under the influence of a controlled substance. Based on his review of the video, Detective Pomplin stated the defendant was showing signs of being under the influence of a controlled substance. Now I found that to be fascinating, because when you're watching a video and this is just me noting something. How do you tell that someone is not just drunk to oblivion versus under the influence? I always wonder about that. You know, like when you look at it. By the way, Deanna, thank you for the 20 there. Thank you, Mr. Tone, for everything you do. You're loved. Appreciate that too. Very much so. Appreciate all of you being here too. Like I said, I just want to go through all of these. I like to be thorough. I don't like the argument. I hate it when the argument is placed, and sometimes accurately, that people are not looking at everything that's stated. Because like I said, there are cases sometimes where someone will paper a case. You know, they'll just throw out motion after motion after motion, and you can't keep up with everything. Like, you can read it, but you can't cover it all. Like, we covered a case like that pretty recently, but most cases, when you look at them, yeah, you can go through everything and try to do that. So the defendant argues that Detective Pomplin did not watch the entire video that the defendant published on social media May 21st, 2024. In support of that contention, he submitted a PowerPoint that contains a clip from that video stream. The clip is less than 1 minute long, does not include any audio. This was a clip from the full video that Detective Pomplin created. It was disclosed to the defense July 3rd, 2024. Defense counsel downloaded it 12:31 p.m. on January 3rd, 2024. What was also disclosed on July 3rd, 2024, at the same time, the PowerPoint clip, was the entire 4-hour, 4-minute-long video from the defendant's channel with audio. This was downloaded by defense counsel July 18th, 2024, 12:49 p.m. This full video has been uploaded to MNDS for the court to review and share with the defendant. So, they're saying, yeah, there was this clip there, but also there was the entire live stream. In fact, we made that available. It was downloaded by the defense counsel. I give a time for that. So the defense argues that the clip on PowerPoint was manipulated, but as you can see from the full video stream, the clip is taken directly from the video at approximately 2 hours, 50 minutes, and 40 seconds into the video. The only editing is to cut the short clip from the entire video. The other brand on the clip may have been from the application used to make the clip. That's true. Watermark. Sometimes the watermark just, you put it up there intentionally. Sometimes it's unintentionally. I mean, that's true. But it says the full video shows that is entirely from the defendant's channel. There are no other labels or markings to indicate that the video is not authentic. Detective Pomplin informed the issuing magistrate that the video was no longer publicly available, but that he was able to view the entire video stream. The entire video is consistent with the statement made by Imholte. Detective Pomplin used his own training as a drug recognition expert to describe the defendant's behavior and how that is consistent with the use of controlled substance. Detective Pomplin did not misrepresent the information. He viewed the entire video. This was disclosed to the defendant. The defendant had this video for over a month prior to the Omnibus hearing. Instead of being candid with the court, the defendant implied that the only video that was disclosed to them was a short clip. This has the appearance of an intentional misrepresentation to the court of what information has been disclosed. I'm curious for their answer to that, because that doesn't look. I mean, again, we can't see the video or anything like that, but if that's the truth, again, if they very much do have the entire video is present, that does seem to go against what they were arguing. That essentially, again, an altered video clip. Like the clips that you might see floating around on Twitter or for some other place. That was the basis versus. So additionally, Detective Pomplin viewed video from the defendant's channel going back several months. Between January 2024 and May 2024, Detective Pomplin notes the defendant's change in appearance, including that he's lost weight, appears tired, and overall appears, quote-unquote, strung out. All of these are common with controlled substance users per Detective Pomplin's specialized training as drug recognition expert and his experience as a police officer. The defendant has failed to make the requisite high showing that the event Detective Pomplin intentionally made a false statement or with reckless disregard for the truth. Therefore, the defendant is not entitled to a Franks hearing. Any challenge to the search warrant is limited to the four corners of the document. The state requests an additional briefing schedule if the defendant is raising a general probable cause challenge to the search warrant. So 2, this is about the firearms. Them being seized. So the seizure of the firearms was lawful under the plain view exception to the warrant requirement. The defendant's argument is grounded in the prohibition on unreasonable search and seizures found in federal and state constitutions. These provisions provide that, quote, the right of the people to be secured in their persons and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause. As a general rule, any search without a warrant per se unreasonable unless the search falls within one of the few specifically established and well delineated exceptions. It is well established that under certain circumstances, items not named in the search warrant may properly be seized. The plain view exception to particularity requirement in the Fourth Amendment is satisfied where an officer lawfully executing a search warrant authorizing the seizure of certain items inadvertently comes upon other items whose incriminating nature is immediately apparent. You know, it really sucks when I'm doing videos of read-throughs like this and I get stuck on a word like that. I'll start a bit like crap and I'll restart instead of just going like in a live stream and I just get stuck on it. Like, try 13, try 14. It's like, oh my God. Police have probable cause to seize an item in plain view if the facts available to the officer would warrant a person of reasonable caution in the belief that certain items may be useful as evidence of crime. To justify a warrantless seizure under the plain view exception, probable cause must be based on evidence, quote, revealed in plain view and cannot be obtained after conducting some further search of the object. Citation omitted. That's gonna. They omitted a citation. I was like, wait a minute. Okay, so the search warrant for the defendant's home was to search for controlled substances. During that search, law enforcement located a number of firearms. The exact models and locations, they're listed in the Supplemental Report 1 submitted by the defense. The officers were acting within their legal authority to search the defendant's home pursuant to the search warrant when they located the firearms. There's no limitation in the warrant that areas of the defendant's home were not to be searched. The firearms were located under the bed in the master bedroom, in the garage, and in the safe in the garage of the home. Searching these locations was authorized by the initial search warrant. When law enforcement found the firearms, it was immediately apparent that they were evidence of a crime. In Minnesota, it is unlawful for a user of controlled substances to possess a firearm. Also located in the home were over 26 grams of cocaine, a Schedule II controlled substance, and 8 dosage units of ketamine. So ketamine as well, a Schedule III controlled substance. So the notation of ketamine as well with it. There was evidence of use of the controlled substances also in the home. In the master bedroom, law enforcement located 3 snort tubes that field tested positive for cocaine. a glass container with metal filter and grinder that field tested positive for cocaine, a bag of cards and dollar bill that field tested positive for cocaine, a digital scale that field tested positive for cocaine, a mental pan. I like that, by the way. It's a mental pan. Use it for mind reading when you're using your snort tube for cocaine. I'm going to say a metal pan that field tested positive for cocaine, 2 metal cutters that field tested positive for cocaine, a $100 bill that tested positive for cocaine, and a cocaine scooper. These items are direct evidence of use in the home in addition to the actual controlled substances found. Also, Detective Pomplin, a trained drug recognition expert, had his own observations of the defendant from his videos that indicated being under the influences of controlled substance, as well as the statement of the individuals from Child Protection Report who indicated concerns about ongoing controlled substance use by the defendant. So let's talk about Child Protection Report, also saying, hey, wait, okay, so all of this information taken together that shows evidence of controlled substance use. When law enforcement found firearms in the home, it was immediately apparent that the firearms were evidence of a crime based on the controlled substance use. There was no need to further search the firearms. The possession is evidence of a crime, making it immediately apparent to law enforcement of their evidentiary value. Accordingly, their seizure was lawful under the plain view exception to warrant requirement. They're telling you, hey, he had drugs in the home. Because the drugs were there, that makes the possession of guns unlawful, therefore. Like, that's the argument straight up, that they're making. Hey, Cindy, thanks for the 21 months. Hey, hello, Tug. I started watching you because that lawyer mentioned you, Depp versus her trial. I watched the last 3 weeks during work and didn't do my job. Hopefully you kept your job there. Yes, there are many trials that are fascinating. That trial was a crazy worldwide trial. But there are a lot of them out there. I appreciate you being here, for sure. So, conclusion. The defendant's motion should be denied in its entirety. The defendant failed to make the requisite high showing that Detective Pomplin made any material misrepresentations or omissions in the application for the search warrant. The defendant relies heavily on their assertion that Detective Pomplin did not view the entire video of the defendant's referenced in the search warrant application. Their argument completely overlooks the fact that the entire video was disclosed to the defendant at the same time as the video clip his argument hinges on. The information provided by Detective Pomplin was accurate and no material misrepresentations or omissions were made. The seizure of firearms is legal under the plain view exemption that to the warrant requirement. Law enforcement was legally authorized to be in the defendant's home pursuant to the search warrant. While searching the home, firearms were located. Firearms were immediately recognized as evidence of a crime, as users of controlled substances are prohibited from possessing firearms. As their evidentiary value was immediately recognized, their seizure is permitted under the plain view exception. So again, that's their argument. I actually think, again, we'll see what a judge thinks with that. I do think that is a strong argument. If there's, again, they get to counter this. We'll see an answer within the next few days for it, but it seems like a pretty strong argument. If they provided the entirety of the video and that was there in addition to, that was relied on. Again, it seems like a strong argument because when you go through, the two arguments here were we need to strike down probable cause because, again, it was based on really two things they argued. Number one, the relationship with Aaron Imholte. If you look at that relationship, it wasn't described correctly. This wasn't a concerned citizen. This was somebody that had actual animus against a person. They made threats and more, is what they were saying. And the state said, well, we did note that there was a falling out. The falling out, that describes. And then again, they note that the threats that were made, they were not threats of, physicality. They weren't trying to go in and actually do bodily harm, nor was there something noted with financial harm, but rather there was a statement that something would potentially be said that they didn't want stated. And I mean, I would agree with again, the statement that was made, that was quoted. Give me 1 second, I'm rolling back. For a concerned citizen. They noted about the 1 minute. I like the concerned citizen argument, though. Just the way it comes up there. But with that, they noted again, quote, may have recently had a falling out. That was the wording. And then, actually, let me pull this up on the screen again, just to make that clear, what the argument was over in this. The statements that they quoted, again, were, peace, brother. It's not what Nick told me when I said I would not be hanging out with him anymore. Now, that was actually a reply to something that Nick stated, I believe, in a local stream. He's saying that wasn't what was stated. The text I got was something about being a flabby, misshapen, doughy piece of shit I am, and the world would be better off if I to myself. Then he said, Nick, sweetie, baby, first of all, get help. Second of all, you better hope. And I said this last night. You better pray to God. I don't say what I want. If I say what I want, mofo, that's Mount Vesuvius. Let's make a quick rule for Nicky boy here. You keep my name out of your effing mouth in ways like that, and I can promise I'll be as good a boy as I can be. He also said he was comparing himself to Lefty Rosenthal. Again, I'm sure most people have seen Casino. If you haven't seen Casino, by the way, what are you doing with your life? No, I'm just kidding. You should definitely watch it. But, again, notes that he was comparing himself, and he said, you want to keep a guy like that happy, right? Because he could blow your shit. He could blow up your shit, right? So those are the statements that they quote. Let's see. Oh, here's... They also said, so this woman who clips a bunch of shit from my show, from Nick's show, DM me. It was Nick telling a disjointed, drunken story on a stream. Here's the clip that riled me up. So they brought that up as the notation for the clip that came up as well. And again, the state is saying none of this is a threat of physical harm, nor is this a threat of financial harm. This is information that he wouldn't want stated there about it. So it's totally different. And they're saying on top of that, too, we didn't solely rely on that for warrant probable cause. So you have that. That's the argument that's going back and forth. On top of that, again, he brought up the clip portion. And within the clip, I said this was a minute long? It's a very short clip, isn't it? They were saying this clip right here, this is all that he had to go on. All the detective he set up for probable cause. like that's obviously edited, number one, they noted. And number two, that's not the entire live stream. You can't say that everything here, that it actually checks out if, and the state said, well, yeah, we had that. But in addition, we have the entire video that was referenced, along with watching many other videos from January to May. So again, that wasn't the sole basis of everything. And it wasn't a material misrepresentation. You didn't have the officer go out of their way with reckless disregard for the truth. You know, he wasn't lying, or he didn't care that there was a lie in stating what kind of a relationship there was. So you have that argument. And then the other argument is about the firearms. It was, again, Rekieta's argument is you can't take those. They weren't defined within the search warrant. There was no basis to go after that. And the state's like, hey, you can't possess those with the substances we found. So when we found the substances, oh yeah, that actually is a plain view exception. Like those items, they play in. So again, we will see another response to that. But this has been the back and forth that we've seen. Like I said, there's more stuff that is going on in the background. Plus, you have everything going on with April. I'll probably put that in its own video, because it's stuff going on with April. Like I said, it connects to a degree, but it's its own thing. You know, it connects as far as what I'm going to say allegedly. What allegedly occurred? Well, you saw all the substances, you saw everything that happened there. So yeah, I mean, it connects to that, but it's not connected to this specific back and forth. Mel, thanks for the 5. If the full video is not from his channel, that is a problem. Yes, it could, you know, here's the other question though. Yes, it could, well, it depends on, you're right, with the location where it actually came from. You know, had it been tampered with, that could be a problem. You also have to think, here's something that comes up in a lot of cases. You have to remember the judges that are involved in this stuff. See, the judge isn't like a you or I. Well, maybe they are sometimes, but more often than not, judges. I remember a judge talking, comparing items, like sharing items, and there was a particular case, and I actually want to define this a little bit better, where somebody had reshared something and made a statement above it. You know, they did a quote tweet, and in that quote tweet, the judge compared that to sharing cat and dog pictures, you know, which they're not the same thing at all. But the way the judge saw that, that's the way they understood the internet. It was a limited understanding of the internet. So you always have to wonder too. And I'm not saying that this will arise in here. Maybe this judge is, you know, he's keenly aware of how everything works online. But again, more often than not, when you run into judges, they have a very limited understanding of how internet works. You have to hammer a point home. And maybe they can hammer that point home. Maybe they can get something. Again, they're trying to tear down, and you expect this, you know. At first, if you can tear down the warrant, you tear down everything that comes after, and it doesn't matter what you find. And that's what they're going for. Whether or not you agree with it. I mean, this is something that you see quite often. Now, I do wonder, in doing this, I wonder if fighting with the state, I wonder how that makes them feel about potential deals that could have been upcoming. Does that change the mindset? Or they're like, should we prosecute? You know, we always talk about, they don't typically like to prosecute people. They like deals. Because you can run on success rate. They don't like a challenge. You know, they like an automatic victory. They all love an automatic victory. That's why they sometimes give out deals like candy. But when you argue with them, even if it's just exploratory, you do have to wonder sometimes if it makes them feel like their case is stronger, or if maybe they just don't like you, what they'd be willing to do. I do wonder about stuff. And again, I know when I say that there will be somebody come in and lecture the whole idea of, well, they're not supposed to do that umbrella guy. No, they're not supposed to allow feelings to conflict with their job. But guess what they do? They're human. You know, when you go in and you question on top of insulting people that have come in the past, you know, there's been a few names that have come up in this that have had some pretty spicy things said about them. And again, you know, there's been this argument, can you say anything? Of course you can. You can say anything that you want to. Should you do that? Maybe not. We'll see how it plays out. Again, you know, the decision on that's really where it runs into more than anything. Like, what should you do? Well, I guess if you win, I guess that's the answer. Eclipse Warlord, thanks for the 29 months. Hey, Tug, it's been a while. So out of touch with all this craziness. Hope you and yours are doing well. Off to dinner with family later. Hey, appreciate you there. Yeah, I mean, this is this craziness too. Actually, for a hot minute, you know, I wasn't sure if I wanted to continue. Because, you know, you had Rekieta talking about his case. He was covering documentation. I thought, okay. But it's just, it's interesting because there's been so many arguments about folks not covering things in good faith. You know, I've had that pointed at me, by the way. You know, I think in talking about this, I've had enough, you know, I'll have people say, oh my God, you're sweeping, but you also get oh my God, you know, you're trying to run. I'm not trying to do either. I'm just trying to sit down. Like I've said before, I would very much hope that for Rekieta and his family, that he gets back on that flow, you know, on the video flow, not the other flow. I'm not talking about getting, you know, involved in substances or drinking or anything. I cleaned up Rekieta, going out, focused, and doing the best for family. I 100% would wish that on someone. I would not wish a negative. Even if something is self-imposed, even if you do something, you know, that hurts you, you fall down, as it were. I don't want to kick dirt on a person. I want them to be able to get up. I want them to be able to see the issues there, and I want them to be able to self-correct and be successful. But there was so much argument that people aren't going through the entirety of documentation. I thought, well, let's go through the entirety of documentation. Let's look at it all. We did from the beginning. We looked at every single item that came up. Now, there will be, if you look at a court record, there will be specific items that they don't really have a lot of bearing in what we're discussing. You know, there'll be requests for something, and you'll have a document, or you'll have a redundancy that comes up. those items, who cares? But the other, for sure. So I want to cover all of that. Again, to make it as transparent as possible. Because there's the argument out there that the state, they overreach. They did X, Y, and Z. Don't you hate this state? And if you have a state overreach, yes, for sure. So you can see the argument yourself. You can see what they're presenting, how they're trying to knock down probable cause. There were a few other things that I actually expected to see. Maybe they will go after evidence themselves, but I had wondered if there were a couple other arguments that I wondered if I would see in going after the warrant's PC itself. Now, I've thought of a few arguments for going after things that were found, like the way they may go with it. And again, when I'm saying that, I'm not making a statement on the items themselves, whose they are, or, oh my God, conspiracy. That's not what I'm saying. I'm just looking at this from a trial aspect. If you went to trial, how do things look? I think the warrant PC will hold so far. If this is the argument, I think it'll hold. But I could be very wrong in that. But I think a judge will say that it holds. Again, we may see more when they flesh it out, though. They'll have a few days. They'll actually add to this. And maybe that'll change everything in perspective. That's also one of the things. When people read an argument by Nick and his team, they may be like, oh man, that's great. Or, you see them as they come up. And so far you have a perspective on it. But again, maybe they can change that. Again, they're also not aiming at you and I's perspective. It's the judge. And going after getting this thrown out totally, I don't have a lot of faith in that. I mean, maybe you do. Maybe you see it totally differently. But anyway, I think what's this been? 2 hours? I think we spent quite a bit of time there. About 800 people that showed up for a document reading. That's pretty good, just to be honest. I'll try to be, again, more thorough in hitting stuff. It's a weird position. I thought with Nick covering his stuff and talking about it, at first I thought, man, maybe I won't cover. I'm not sure. And there were a lot of... here's another thing too. In the coverage, it's an interesting place because you have a lot of animus between people that are covering and Nick. I mean, you have just see a lot of confrontation. If you're not on Twitter, you might not see it as much, but if you look at the discussions on Twitter, they are very spicy right this moment. There are a lot of lawyers that are going back and forth with Nick. And for myself, I've not had that. I did have an exchange, but that exchange was over stuff that came back initially, about statements about police officers. I was like, you shouldn't make statements like that. Again, he disagreed. He was like, make whatever statement I want to. And that's his right. He can do that. I don't believe in motivating the police. However, I don't wish negatives on anyone. No, on either side of that either. When I say, there's enemies or there's conflict, it's gotten nasty. I just want to look at the documents again. I want to be able to look at that, and if I think there's an argument that's sound on Nick's side, if they argue something, you're like, hell yeah, like that makes sense, I'm going to say that. Again, we would do that with a typical case. At the state, if it doesn't look like the state's going to knock something down. I am curious. It is an interesting thing, though, as Mel noted. Where did that live stream come from? You know, where was it uploaded from? Because Rekieta did pull that pretty quickly. You know, it's interesting too. I think back, and again, this is not meant as a told you so or anything else, but I remember when that live stream came up, there were people that were like, yo, man, your house is going to get raided. Like, this is going to happen. And it did. Maybe that's... I have my personal feelings on stuff too, as far as I think Nick was on a very life-threatening trajectory as far as what he looked like, you know, from January to May. Like, whatever he wants to say he was doing, whether that's against substances, controlled illegal substances, or whether that's drinking, whatever the case may be there. I would not wish this on anyone. I do think, however, that if there wasn't something that that interrupted what was going on, I think we would have seen a very bad outcome. Like, I felt like, you know, he was falling. You know, he was spiraling. And there are still people that are like, oh, well, he's doing this or that. Well, what I'm talking about is that use, you know, that hole that you fall in. And it felt like the bottom was coming up real fast. And he needed something. Like I said, I wouldn't wish this type of intervention on anyone. But there needed to be an intervention of some sort. But anyway, I'm going to end here. I appreciate you folks. I think tomorrow, I think I'll cover up the What the Hell's police call. I haven't hit it yet, but anyway, I'm going to call it here. Appreciate you folks.